Good afternoon. My name is Brendan Maher. I am a professor at the University of Connecticut Law School. I am the director of the Insurance Law Center, and we are very proud to host this event, a discussion/debate about Professor Daniel Schwarcz's article, "Is U.S. Insurance Regulation Unconstitutional?" This is an event that we are live streaming for the many people in Hartford who had expressed interest in hearing these two eminent professors discuss the issue, but were unable to join us in person. Before I begin, I'd like to thank Professor Schwarcz and Professor Grace for joining us. Professor Schwarcz is here from the University of Minnesota. Professor Grace is here from Temple University. And I'd like to pay a compliment to Professor Schwarcz for writing this article. I think in insurance terms, this is one of the most important articles that's been written in the past decade at least. And I'd like to thank Professor Grace for coming to discuss it with us, because I think this article is one that deserves to be discussed both for general consumption and for an expert audience. And we're hoping that this discussion will be one that experts can follow and enjoy. And I've asked Professor Grace and Professor Schwarcz to not shy away from details and discussing issues that they might normally choose not to discuss if the audience was generalists. So they're going to dig into the details to the extent they feel it's appropriate. And with that, I'd like to invite Professor Schwarcz to speak for about 25 or 30 minutes about his article and his thesis. Thank you.
Great. Well, thanks so much, Brendan. Thanks so much for coming. Thanks to those of you out in the world who are actually live streaming this. So I'm going to be talking about the article. It's forthcoming in the Connecticut Insurance Law Journal any day, but it's also available online. And I'd really encourage you actually to look at the article itself. You can just Google it. That's the easiest way to do so. But let me sort of give you an overview first of what I'm going to do in this talk and how I'm going to build the case that current U.S. insurance regulation is actually built on an unconstitutional foundation. So what I'm going to do first is just provide a basic overview of the NAIC, consistent with my sort of basic understanding of the audience. I'm probably not going to spend too much time on that, because I assume you all have some familiarity with the NAIC. After that, I'll talk about how states delegate power to the NAIC. And then, after I do that, I'll explain why they delegate power to the NAIC, which goes back to what's known as the NAIC Accreditation program. From there, I'll set the stage by explaining the law on delegations and when they are or are not constitutional. And then I'll make the affirmative argument that the delegation of power that states make to the NAIC is constitutionally suspect. Finally, what I'll do is I'll suggest some potential remedies. All right. So let's start off with an overview of the NAIC. The NAIC is a not-for-profit corporation. It has about 500 employees, located principally in Kansas City, but also in Washington, D.C., New York, and it does a tremendous amount of things that are really not really too controversial. So, for instance, it produces model laws and regulations. It does things like facilitate conversations among regulators. It does some advocacy work. It provides some information. Much of what the NAIC does, I think, is not controversial. Okay? So I'm just going to be focusing on one element, albeit one essential element of what the NAIC does. That's going to be the focus of my critique. Before I get there, though, I think it's really important to understand the funding model of the NAIC. The NAIC has a $100 million annual budget, okay? And most of its budget is funded by the industry indirectly, as the industry pays for things like access to data or various regulatory filings, okay? So, with that understanding of the NAIC in place, I now want to spend some time understanding how states delegate power to the NAIC, because this is really the crucial point that we're going to be focusing on, okay? What various state statutes do is they incorporate by reference NAIC materials, okay? So state statutes, for instance, say insurers have to set their reserve levels in a manner that's consistent with the manual that's produced by the NAIC. Or insurers have to abide by the accounting rules that are specified in NAIC manuals. This is a cross-reference. And a statutory cross-reference in and of itself isn't really troubling. In one way, you can just understand it like short-term, right? It's just, here is what we want to include. Rather than writing the whole thing down, we're just going to cross-reference it. But where the difficulty comes into play is with respect to something called dynamic incorporation by reference. Dynamic incorporation by reference doesn't just cross-reference existing materials, it cross-references any future versions of materials. And that's what state statutes do here. So they don't just say insurers have to follow the rules in NAIC manuals as they are currently laid out at the time the legislation is passed. Instead, what they say is you need to follow the rules that are laid down in the NAIC manuals as they exist now or in any updated versions of the NAIC manuals. So recognize what the effect of this approach is. It's a delegation of power to the NAIC. It says, NAIC, you can write the rules on any of the topics that we cross-reference in the statute, and those rules will automatically become the law of the land in this state. Okay? So that is what we see with respect to fundamental elements of state insurance regulation. For instance, and in my view, the most problematic example here is the NAIC Valuation Manual. The NAIC Valuation Manual is, I believe, over 1,000 pages long, certainly many, many hundreds of pages long. And it's a new manual in the last 5 or 6 years that specifies the methods by which life insurers have to set their reserves. Now let's understand how fundamental this is to insurance regulation. Reserves are the primary liabilities on insurers' balance sheets. That means that how you set your reserves affects your capital, because your capital are your assets minus your liabilities. Capital regulation is the core solvency tool of insurance regulation. So we're talking about a delegation of power to the NAIC effectively to say how much we anticipate we're going to have to pay policyholders in the future in a way that fundamentally goes to the essence of insurance regulation. And all of the details about the rules you have to follow, the procedures you have to follow, the assumptions you have to make, the reporting you have to make is contained in this massive NAIC document that the NAIC can change and adjust as it sees fit. And as soon as the NAIC does so, that becomes the law. Another example, the Own Risk Solvency Assessment Manual, or ORSA Manual, is an NAIC manual that is dynamically incorporated by reference in state laws. States say, insurers, you have to abide by the NAIC ORSA Manual and the latest version of it. The ORSA Manual contains details about corporate governance. How do you report on your corporate governance? How do you do risk assessment at the corporate level, at the parent level? Fundamental issues of state insurance regulation are therefore delegated by the state to the NAIC. Another example, the Statutory Accounting Manual. This is a long-standing example where, as many of you likely know, insurers have to follow particularized rules about accounting. We refer to those rules as statutory accounting principles, even though they're actually not contained in the statute. All the statute says is you have to follow the rules as laid out in the latest version of the NAIC Statutory Accounting Manual. And the NAIC then has the authority to set all the accounting rules that apply to the industry. So let's just stop and take stock on where we are. What we've seen is that states delegate to the NAIC a private nonprofit entity funded by the industry many of the core powers and core responsibilities of state insurance regulation, ranging from how much they're going to have to pay to policyholders in the future, to how they deal with risk at the consolidated level, to how they calculate the value of their assets and liabilities. Now, why do states do this? Because understanding the why here is essential to understanding the potential legal problems. It turns out that the reason why has to do with something called the NAIC Accreditation Program, which really goes to the heart of state insurance regulation, even though it's not widely understood. The NAIC Accreditation Program operates by the NAIC accrediting state insurance departments. So it says a state insurance department can do its job with respect to solvency regulation. And it does that by saying, one, you have sufficient resources, two, you have sufficient personnel, but three, and critically for present purposes, you have adequate laws and regulations to ensure the solvency of the insurers in your state. Now, in order to meet the bar that the NAIC requires of accreditation, what you must do is pass a series of model laws that the NAIC itself produces. So in order to be accredited, you need to have the NAIC model laws on capital requirements, on reserve requirements, or the substantial equivalent. So, therefore, states must pass a subset of NAIC model laws to be accredited. And it just so happens these are the very same NAIC model laws that dynamically incorporate by reference these documents. So far what we've learned is the NAIC says, look, if you want us to accredit you, you have to delegate power to us. That gets us part of the way to understanding why states delegate power to the NAIC, but not the entire way. Because the next obvious question is, okay, but states don't have to do this. They don't have to become accredited. Why do they choose to become accredited if it means essentially giving away power to the NAIC? And the answer to that is the following. Within the model laws that are required for accreditation is an essential provision. That provision states that an accredited insurance department can only defer to the solvency regulation of another accredited insurance department. What that means is this. If a state insurance department is not accredited, then any insurers that are located in that state are going to have to be independently regulated in every state they do business. Let me give an example. We're currently in Connecticut. There are many insurers domesticated in Connecticut. If the Connecticut Insurance Department lost its accreditation, that would mean that every insurer domesticated in this state would have to be independently reviewed for solvency in every state they did business. They were licensed to do business in. That would produce a tremendous amount of costs for those insurers, of course. Generally, the way state insurance regulation works right now is that the primary regulator of an insurer's solvency is just the state in which they're domesticated, not the other states they're licensed to do business in. And that helps ensure we don't have overly burdensome and frankly duplicative regulation. But if a state loses its accreditation, all of a sudden all the insurers that are domesticated in that state now are subject to a tremendous amount of overly burdensome, repetitive regulation by law, because the insurance departments where they're operating are not allowed to defer to that insurer's home state. What's the result? Well, if a state lost its NAIC accreditation and it didn't fix the problem, most insurers would re-domesticate to another state. Why would I choose to domesticate in Connecticut if that meant I was regulated everywhere I wanted to do business, in every one of the 50 states, if I was a national insurer? Instead, I would just move to another state that was accredited. Now I'm only regulated by one state, not 50. And here's the catch. The NAIC Model Law on redomestication, which also is an NAIC Model Law, says if you want to redomesticate, you need to move your principal place of business. So, let's understand this. If Connecticut lost its accreditation from the NAIC, insurers domesticated in Connecticut, a huge part of the economy, would essentially be forced to move their principal place of business to a different state. What does that mean? It means for all intents and purposes, retaining your accreditation is not optional. No state could really, at this point, all states are currently accredited. No state at this point could become unaccredited realistically, because the threat would be that all the insurers would leave that state. Why? Because of the very scheme the NAIC created. So that's why states not only delegate power to the NAIC, but can't take that delegation back. Because if they were to undelegate from the NAIC and say, you know what? We don't want to follow your rules you require for accreditation. In particular, we don't want to delegate power to you. We want to set our own insurance rules. The NAIC would be able to come back and say, great, well, we look forward to all of your domestic insurers redomesticating to another state, moving their principal place of business. How will that work for you, state legislator? So, we have a system now, let's review, where states delegate power to the NAIC, a private entity funded by the industry, where that delegation of power has to do with core principles of insurance regulation, and where it's the case that states, for all intents and purposes, do not have the practical capacity to undo that delegation of power. Now we've set up the facts, let's look at the law. There's this broad principle in constitutional law called the non-delegation principle. Many of you, at least the lawyers in the room, may be familiar with it in the federal context, where it's a little bit of a paper tiger. But every state, of course, has its own constitution. And every state constitution also contains a non-delegation principle. Some states actually explicitly have it in their constitution. Others, it's just read into the Constitution by the courts because the Constitution says that the legislative power is vested in the legislative branch. So it makes sense that if Connecticut, for instance, wanted me to make the laws, this Connecticut legislator couldn't pass a statute that says, you know what, Dan Schwarcz is great, he gets to make all the laws of insurance regulation.
I would enact that.
I appreciate it, but it would be unconstitutional because it would violate the non-delegation doctrine. There are limits to how a state legislator can delegate powers to other entities. Now, those limits are going to vary by state, by the state constitution, and by the way the state constitution has been interpreted. But there are certain core principles that can be deduced from the case law across the 50 states and even the federal case law, because we're dealing with a principle that is similar for the state constitutions and the federal. One of the core principles is this: delegations of power to private entities usually are not problematic. I mean, that's how administrative law works, right? The legislator delegates power to a public agency. But once the legislator is delegating power not to a public entity, but to a private entity, things get a lot more troubling. And there are a lot of good reasons for this, right? Private entities are not subject to many of the procedural restrictions that public entities are. They can be subject to conflicts of interest. They can use delegated authority in a way that enriches them at the expense of others. So it makes sense that whatever constitution we're talking about, delegations of power to private entities are going to be looked at differently. For that reason, that's usually where courts start when looking at whether or not a delegation of power to an entity is constitutional. They look at the public versus the private character of the delegate. There's a well-known Supreme Court case applying this principle where Congress delegated power to Amtrak, which was technically incorporated as a private company, but created by Congress, largely funded by Congress, and had in its corporate chart and was subject to many procedural restrictions by law. And the Supreme Court said, you know what? For purposes of the non-delegation doctrine, even though formally you're a private entity, in practice you're enough of a public entity that we think we're going to sort of apply the rubric of public non-delegation. But there are other cases going the other way. For instance, there are many state cases looking at delegations of power to the American Medical Association in the context of workers' compensation. Those universally treat the American Medical Association as a private entity. It was privately created, it's not subject to public safeguards, and it's privately funded. So the first thing we have to do is look at public or private, not in sort of simplistic formal terms, but in substantive terms. But there are other factors that courts look at as well. And now I'm going to have to generalize the case law across the states because, again, there are 50 different constitutions with 50 different, 51, and even more, I guess, if we're thinking about, D.C. and so forth, that we have to look at. But most of them say, look, not only is the public or private character of the delegate relevant, it's also relevant whether or not there are procedural or substantive restrictions on the delegate. So, for instance, if I delegate power to a private entity and just say, go, that very well might be unconstitutional. But if I delegate power to a private entity and then say, you know what, the rules you come up with are subject to judicial review or are otherwise constrained in a way that is verifiable, that might well push it back into the constitutional space. Also relevant is the legislator's practical capacity to monitor or police the delegation of power. Because if the Connecticut legislator decides to give me power to make insurance regulations, presumably, if I do a bad job, one response might be they'll reverse that delegation. So I'm painting with broad brushstrokes here, but these are some of the fundamental principles that animate the case law across the states. So now we have our facts, NAIC power as a result of state delegations. We have our law. Let's apply our law to the facts. And when we do so, the argument in my article is we see relatively clearly that the status quo, the backbone of much state insurance regulation, is unconstitutional under state constitutions. First, is the NAIC a private entity? We know formally it is. It is incorporated as a non-for-profit entity in Delaware. But we know that that's probably not where the inquiry is going to end. I would submit to you, though, that even if we look more substantively, we see the NAIC is more of a private entity than a public entity for purposes of the non-delegation doctrine. For instance, who funds it? The industry. Is it subject to state sunshine laws? No. Is it subject to any legal procedural requirements? No. Are its decisions reviewable by any court or outside entity? No. Was it created by the legislator? No. It was created by state insurance regulators as a private association of state insurance regulators. All of these factors distinguish it from a scenario like Amtrak, where we have a private entity that has more public attributes. Here, I think it's very clear that the NAIC is both formally and substantively a private entity for purposes of the non-delegation doctrine. That then invites the more searching scrutiny that courts apply. So we now have to look at, is there independent review of what the NAIC does? Substantively or procedurally? The answer is no. Nothing the NAIC does is subject to challenge in any court, in any administrative body. Now, there are some exceptions, and I need to recognize them, and to the extent this were actually litigated, and I hope someone litigates this. This is going to be the important part on the other side, or at least one of them. States do sometimes, depending on the circumstances, have the capacity to depart from NAIC manuals. But typically, in order to do so, they have to promulgate a regulation. So in other words, there's no automatic review. If a state doesn't want to follow the NAIC's language in a manual that's incorporated by reference, they have to affirmatively act, and they have to affirmatively act in a way that's very cumbersome and burdensome and difficult, which is why you almost never see this in practice. In practice, what the NAIC does becomes the law in the states, and states don't depart from it. By the way, it's important to think about analogs here, because there are analogs. One of the most important is the SEC's delegation of power to FASB to set general accounting principles. The SEC says, FASB, you can come up with the rules of general accounting principles, and those are incorporated by law, dynamically. So it's very similar. But here's the key, and by the way, FASB is definitely a private organization. But here's the key difference. The SEC has veto power over what FASB does. And as a practical matter, if the SEC doesn't like what FASB is doing, it can and does change it. By contrast, no independent individual state has any veto power over what the NAIC does. And here we have to recognize the distinction between the federal scenario and the state. Because when we're looking at state non-delegation doctrine, our relevant unit of analysis is not all states collectively, it's each individual state. Connecticut's Constitution says the Connecticut legislator cannot delegate power to a private entity. And so, if they're going to do so, they're going to need to retain some power. Connecticut has no power to push back on the NAIC's delegation of power, or use of that power. And the only way it can really do that is by convincing lots of other states. So we have a scenario in which the state legislator delegates power to a private entity, but then that state and its elected officials through its citizenry has no power effectively to oversee it or veto it. Finally, this goes back to the accreditation program and the why. States do not have the practical capacity to take back from the NAIC the power that has been delegated to them. Why? Because if a state said, you know what, we don't want to delegate power to you anymore, NAIC. We don't want to follow your statutory accounting principles. We don't want to follow your valuation manual. They would lose their accreditation. Accreditation requires that you have sufficient laws. Sufficient laws require that you have the NAIC statute models or the substantial equivalent. So, if a state did that, it would lose its accreditation, which would then result, let's come back all the way over here, which would then result in the insurers domesticated in that state fleeing the state, because they would otherwise be regulated in every state where they did business. And fleeing the state requires, as the NAIC model laws specify, moving your principal place of business. Let me illustrate this. The NAIC and state regulators are fundamentally changing the nature of state insurance regulation with the valuation manual, which is fundamentally changing how insurers calculate their reserves. No longer do we specify in a formula how they're going to specify their reserves. Now they have a tremendous amount of discretion as guided by this 1,000-page manual. Many states were not happy about this. And the biggest one was New York. New York published a critique of this, saying there's no way we're going to do principles-based reserving. This, by the way, looks exactly like what banks did in the 2008 crisis, having discretion to set their own capital levels based on internal models. We're troubled by this. Formulas are imperfect, but at least they work. Well, what happened to New York? Over the years, the NAIC pounded away and then eventually said, you know what? We're going to make the valuation manual and the law that dynamically incorporates by them by reference an accreditation standard. And if you don't adopt principles-based reserving as specified in our model law, you're going to lose your accreditation. And in the past year, New York has finally relented and is adopting principles-based reserving because they recognize that failure to do so would result in very harsh practical problems. So, we have delegations of power on really important issues that are being forced down the throat of states by the NAIC, with state legislators having no practical capacity to push back. That violates the third core thing that courts look at. So it is my strong belief that if someone were to challenge the NAIC's structure in court, they would likely prevail. And let's be clear, states have robust non-delegation doctrines. They invalidate on a constitutional basis delegations of private power to entities all the time. Pennsylvania just did it. Struck down a workers' compensation law that delegated power to the American Medical Association by letting the American Medical Association draft the rules regarding impairment that were included in the statute. So this is not a theoretical threat. This is a threat to the essence of state insurance regulation. Now, I want to be clear, because I know Professor Grace is going to come up here and say, yes, but the accreditation program does great things. I agree. The NAIC does good work, it has good people, and the accreditation program actually is the backbone of state solvency regulation because it works, because it's effective. It's way better to have the NAIC, through lots of experts, coming together and drafting reasonable rules and having states follow them. But if it relies on an unconstitutional structure, the backbone of state insurance regulation is problematic. And it's problematic not just as a formal constitutional matter, it's problematic because there's no accountability. It's problematic because it creates incentives for the NAIC. Remember those conflicts of interest? How are they funded? Fees from the industry. Why does the industry pay these fees? Partially to get access to the NAIC Valuation Manual. They had to pay to get the laws the NAIC writes. And what does that mean? Well, the NAIC is going to be changing those rules all the time. Talk about conflicts of interest. So we have a system that works, but it's a system that is built upon conflicts of interest, lack of accountability, lack of input. So we need a solution. So I don't think the solution is optimally in the end game going to be just get rid of the accreditation program, get rid of the NAIC. As I said, the NAIC does good work, and there's a reason why the accreditation program is in place. I think instead, we need a system that ensures uniformity, but that creates accountability and limits conflicts of interest. And to get there, I propose a... Ooh, there we go. Question? I propose an interstate compact. We already have an interstate compact for approving life insurance products. An interstate compact can create a public entity that can review what the NAIC does. So recognizing, I'm not suggesting get rid of all the expertise of the NAIC. I'm not suggesting get rid of the accreditation program. What I'm suggesting is hold the NAIC accountable by ensuring that whenever it acts with the force of law, there is some independent public entity that can review what it does to ensure that it's not marred by conflicts of interest, to ensure appropriate process. That compact could be staffed by a rotating panel of state judges. Probably not state insurance regulators, but in theory it might be able to be. But the core goal here is that if the NAIC, when it acts with the force of law, has to explain what it's doing and justify what it's doing to an independent public entity, you've now got a system that looks a lot more like FASB and the SEC. You've now got a system where FASB can't act in a way that just benefits itself. It has to be held accountable to the SEC. Similar here. The NAIC would have to be held accountable to this new entity created by the compact. And if people said, why are you updating the valuation manual? Isn't it the case you're just doing this so people buy the new version of the NAIC Valuation Manual so you get millions of dollars to fund yourself? A court would listen, or an entity would listen, and maybe say, you know what, go back. Or you know what, maybe you can't sell the valuation manual. You need to put a public version of it on your website. Now, I actually should clarify, because I made a mistake there. The valuation manual is publicly available. The statutory accounting practices and procedures manual is not. And the only reason the valuation manual is publicly available is because it's new. Eventually, I bet the NAIC is going to start selling that too. So, ultimately, my argument here is not, let's completely change state insurance regulation. My argument is that as it exists right now, the foundation of state insurance regulation is unconstitutional for real reasons, but we can fix it if we pay attention to the problem. And this is where I want to end. My beef with the NAIC is that they refuse to pay attention to this problem. They refuse to come here and debate this. They refuse to publicly respond to my comments and my article. They sent me a private email explaining why it's wrong from the general counsel. They're willing to say it behind closed doors, but they will not engage with this issue. Running away from issues is not the way to solve it. And so I wish and hope that they're forced to deal with this because people actually make them by challenging the backbone of state insurance regulations' constitutionality. Thank you.
Thank you, Professor Schwartz. Just a comment while we're here midstream. Some people have arrived in person to watch this debate, and some of the people who've arrived are unquestionably experts in the field. And so I'm concerned that those people who have questions might have to leave before our event is over. And so I just wanted to quickly poll the audience. I wanted to make sure that some of the people in the crowd would get a chance to answer questions. Does anyone have to leave before 1:30? Because that is when we had envisioned the question asking would occur. Okay, one fellow. He's good though. He'll send his questions to me. Okay. The other thing is, before Professor Grace starts, I do want to announce we did invite the NAIC to participate in this event. We very much hope they could come and respond to Professor Schwartz's article and his arguments. They declined to do so. Professor Grace?
So I'm going to take the liberty of using one of Dan's slides in just a moment. I'm also going to get my timer out, so I allow, because I'm a professor, and there's not enough time in the world for me to talk. Yeah, there never is. But I'm an old professor, and I can't figure out how to use my clock. There we go. I'm just going to leave that up for a second. My name is Martin Grace. I'm a professor at Temple University, and I want to thank Brendan for inviting me. I want to thank Daniel for writing a really provocative paper. I mean, we're talking. You know, you're here, so you and 8 other people probably think this is the most provocative topic on the face of the earth right now. But in a nutshell, the NAIC pressures states to conform to its unreviewable mandates, as its mandates are encoded into state legislation or administrative rules. And this is an unconstitutional delegation. Daniel said that very eloquently for the last half hour or so. So I think his point is easy to understand. It's his paper is really well written. It's detailed. There's just a lot of interesting information. And I've been, you know, a student of regulation for 30 years or so, no, longer than that. And I learned things from this paper. So I encourage you all to read it, even if you are suspicious about his conclusion. Now, I would just like to point out that I am not the NAIC. I didn't know if you noticed, but I am not the NAIC, and I have never been a regulator. I've testified before state insurance commissions and state legislatures about basically premium taxes. I'm probably the only person on earth that really cares about it, but that's where I've worked mostly with regulators. With one exception, I did work for the NAIC as a consultant in the early 90s on one of their first solvency responses. When they developed the financial analyst statistical tools. A colleague of mine, Scott Harrington, did a lot of the statistical analysis to sort of show the value of this. So other than that, I've been to a couple NAIC meetings. I know some insurance commissioners, but that's the closest tie I have. So when we talk about this debate, I'm not really representing the NAIC. I'm sort of thinking about this from a regulatory framework. So some of the things I'm going to say, the NAIC probably would agree with me, and they probably might say other things too that are stronger. But I just want to let you know these are my particular viewpoints. I also want to let you know that I waffle on state versus federal regulation, with a lean towards an optional federal chartering approach. So I've written a lot of things kind of on that, but I don't really have a strong opinion about every part of state regulation. In fact, I got to testify either for Senator Dodd or Representative Frank's committee. I can't remember where it was, but one of my friends, after reading my testimony, said, "You're no friend of state regulation." And I said, no, that's not true. I'm no friend of bad state regulation. Okay, I made a very different. So I waffle, So I just want to let you know where I'm coming from, which is probably going to lead to a kind of a pro-state approach to this. And in addition, while I am a law school graduate, I do not presume to tell law professors that they are wrong. Now, especially if they're likable and smart like Dan, But that hasn't stopped me before either. The point here is that my observations lean a little bit more towards policy rather than state constitutional law. So I'm going to sort of give you at first the NAIC's kind of best argument, I guess. And Dan got an email from them, so he probably knows what their real argument is. But Congress delegated authority to the states in the McCarran-Ferguson Act back in the mid-40s. And this was a tremendous kind of reverse delegation under the Commerce Power. So this is unprecedented in its importance, I think. And since that time, the NAIC has been referred to by enacted legislation some 25 times, including the the Affordable Care Act, Dodd-Frank, Gramm-Leach-Bliley. They all mentioned sort of the regulatory role of the NAIC in some meaningful way. This is, I think, also important because it gives it I don't know if it's a delegated authority from the federal government to the NAIC, but it's something to have in the back of your mind that the Congress is very aware of the NAIC and its role in state insurance regulation. Also in the early 90s, Congress in the form of former Representative John Dingell, may he rest in peace, and his Commerce Committee, it wasn't just him, it was his whole Commerce Committee, threatened the states with preemption if they didn't act more uniformly and work to put teeth in state solvency regulation. Dan's basic argument is that those things that they actually started back then are the offending instruments today. So I would say that the history of this shows that the federal government had a gun to the states. Well, I guess we don't use guns in schools anymore, but it had pointed a serious preemption weapon at the states, and this is their response to it. And the accreditation was also part of that, too. States saw what happened after the savings and loan crisis in the mid-'80s, where the federal government basically has ran rampant over state banking regulations, with good reason, too. So I'm not trying to defend state banking regulators. They allowed a crisis to balloon that it took, I think, about 15 years to resolve. And so Congressman Dingell and the House Commerce Committee didn't want to see that again in the insurance industry, especially when some very large insurers started to go bankrupt, in part because they had some of those same assets those savings and loans did. So this was a very strong congressional pressure for the NAIC to do something. But even prior to the McCarran-Ferguson, the states had come together to form information sharing and model law developments and rule development under the auspices of the NAIC. It goes back to the 19th century. This has been around for a while. At first, as Daniel pointed out in his paper, I don't know if I actually knew this. It was just a sort of unincorporated association. It was probably an old insurance guys club. And they met and smoked cigars and talked about their problems. They probably didn't meet quarterly even. They probably met once or twice a year. So it was a very different kind of organization. It wasn't until recently, especially basically after Congressman Dingell's letter to the NAIC, that they became this different kind of organization, a nonprofit. Daniel described it very correctly. It's exactly what he said it is. And it is made up of, the regulators from every state and territory in the United States. Now, the NAIC does not mandate that its members adopt its model laws. Now, Daniel may disagree because there's some sort of coercion under the accreditation statute, but states choose to do so. This is an affirmative choice of the states. In fact, I had a PhD student. I'm a professor in the business school. I have a law degree and an economics degree, and I work in both law and the economics of regulation area. And I had a PhD student look up, there's 929 model laws that the NAIC has put forth. They have an average adoption rate of 16 states. So this is, consistent with what Dan said, that this is something they do and we think it's a good thing. And there's a median adoption rate of 9. So it's not like the NAIC has a lot of coercive power on a lot of the things it produces. And in fact, it recognized that, and it's now more difficult for someone to propose a model law. They have to sort of suggest that at least a large number of states, I don't know if it's not a majority, but maybe 40% of the states would adopt the law. But this is kind of an important thing. This is not coercion. For the most part, this is something that is up to each individual state to do. So, and not only that, you don't have to adopt the law in toto. You could just pick parts of it. And you can pick a part and change a part. So this is a model law. It's a proposal, and the states get to choose which ones they want to do. Okay. What's interesting also, I want to point out that there are only 29 adoptions of all those 925 with more than 40 states. And there's only 3 with adoptions of 50 or more. And those are probably the 3 that Daniel has talked about. So this is not a common modus operandi of the NAIC. There's also a lot of public input to these model laws and rules. Even though the NAIC is not your standard administrative agency under the APA or the state APAs, it operates in many, many, many ways like that, in part because it's staffed by state regulators and their staffs. And they have to put these things before public hearings. And every industry representative that wants to talk, every regulator that wants to talk, every insurance professor who wants to talk, and any other kind of gadfly out there, including us, gets to talk at one of these hearings if they want to. That may actually not be true, but many people get to talk, not everybody who wants to. But there's public input. And these proposed model laws come before a state legislature to enact. The state's legislature gets to figure out what it's doing. And when the model law on risk-based capital was passed, I was really involved in following this at the time. There were long involved discussions whether the state should adopt this. So even though it had been passed and made as a model law by the NAIC, there was still tremendous discussions in the states. And the states really aren't equipped to come up with regulating a financial institution on their own. They need the NAIC for this type of rule, regulation, and handbook. Because, Dan's talking about these handbooks, in many respects, if there's some nefarious scheme to extract money out of people, they are expensive, and it ticks me off that I have to pay for them myself. So I do get that. But they are very detailed, and I can't imagine that the NAIC is writing them and changing them just so that they can get more money. They have other ways of getting money that are a lot more remunerative, and that is when an insurance company files its data with the NAIC. The NAIC charges them for that service.
Why do they have to file it with the NAIC?
Oh, they file with every state.
I know. Why do they have to file their data with the NAIC?
Oh, in part because the NAIC. Can we wait till I'm done? Yeah, we can. Then we can have a debate.
Yeah.
I'm actually not really here to debate. I'm here to discuss. But anyway, so there is public input to these model rules and regulations. Now, this is my personal comment. So what appears to be troubling is this dynamic cross-referencing of NAIC rules that Daniel's talking about. And this does not sound like an NAIC problem, though. This sounds like a state problem. And this can be addressed in state courts and legislatures. And this is I think, really important. So the way Dan paints the picture, which I almost agree with, the NAIC is out there doing this, and this, and the states are kind of stuck with it. Well, the states have legislation. They have constitutions, as Daniel pointed out. They have constitutions. They can do things. And one of the things they are charged to do is actually pay attention to what they're doing. Now, that is actually asking a lot, and I understand that. And so, but I think Dan's approach to this is very pointed, cutting edge. What on the very edge of the sword, what do things look like? Well, on the other edge of the sword, the dull edge of the sword, that legislatures do not understand a lot of what's being passed. And so the NAIC, to its credit, is the one that tries to explain and why it's that way. Okay, so in a small little thing, I also like to change the title of the paper as it infers or implies it's insurance regulation unconstitutional nationwide. And this is a problem because I don't think it's universally true that every state would strike the NAIC rulemaking and behavior as an unconstitutional delegation of authority. That's kind of interesting because what it does is it creates a massive practical problem, a hodgepodge of constitutionality and unconstitutionality across the states. And if that started happening, I think as a practical matter, Congress would come in and do something right away. But, it took over a year from Southeastern underwriters to the Maher-Ferguson Act's passage. And what a year that would be if we had this problem today. And at the time, they were fighting World War II. I think the day Maher-Ferguson was passed was the day before D-Day. So there was a lot of stuff going on in Washington. Now there's not as much going on, but I just can't imagine Washington working as quickly as they did in the 1940s to get this fixed. Okay, so let's just do a thought experiment. And again, I am not an expert in administrative law or state constitutions, but I did take administrative law, and I really know the Florida Constitution for some reason. I went to school there, and I got the book award in the Florida Constitution. Now, that means nothing, but I hadn't thought of that in 35 years, so I thought I'd mention it now. So a thought experiment. If the NAIC decided to change its risk-based capital model law or its own risk assessment law, and to say they increase the required level of capital for some reason, and it would have to adjust its handbooks and worksheets and directions to do this in part, but it also would change the model law. And this would have to go before state legislatures again. And it wouldn't do this in a vacuum. State employees working as staff for the NAIC's committee structure would develop drafts, just like regular staff does now. The draft would be subject to public comment and discussion. Now, the public comment and discussion wouldn't be like we find in the Federal Register. It'd probably be more like we find in Florida, where I went to law school, in the Florida Rancher, that newspaper of record where everybody hides their public announcements. The NAIC probably would post it around. So from some perspective, I'm not sure that everybody in the country would understand that the NAIC is thinking about a new rule. But how many people know what the FCC does, or OSHA does, or the EPA does? It's not clear that the average person knows. But the people who are interested really know what's going on. So from that perspective, there's proper notice for and ability for the public to comment and discuss. Insurers, actuaries, and the public, academics, they can weigh in. The NAIC would then issue a final rule or model law. And this sounds a lot like a formal notice rulemaking procedure under APA type of regulation. And I submit there's more opportunity for interested parties to have input at this regulatory process as there would be in the state. So if you thought about it, if the state of I pick on North Dakota, was going to put a new insurance regulation or law in place through the legislative process or the administrative law process, how many people would show up in North Dakota to comment on this? I'd say very few relative to the number of people that would show up before an NAIC committee meeting. So this is a very different scale of operation that's beneficial for state regulation. Now, at this stage, if this is a normal administrative process, a party challenging the rule or law would be able to do so for reasons such as the rule being arbitrary and capricious or the rule is ultra vires. However, nothing is ultra vires from the NAIC, and that's what I admit that's one of Dan's problems too. The NAIC can do whatever it wants, it appears. For it has no original delegation statute of any kind, but it does have a constraint, and this constraint is really substantive. It's not just some magic rule that's a 50C3 corporation that does X, Y, and Z. The NAIC stays in business because it has moral suasion ability, has some moral authority to make rules, propose rules in these areas. It is not some crazy, a crazy wild group out there just making up stuff to extract rents from states. It is doing this because it has legitimacy and it needs to keep that legitimacy. Because going back to Daniel's point, if the NAIC went off the reservation, the industry wouldn't be part of it and the states wouldn't be part of it. So this is I think, an important thing to sort of think about. So it requires external legitimacy, but it is not an administrative agency in the typical sense, and it really has to use its reputation to enhance regulation, to promote uniformity when it's needed. And so I would say so far, nothing is unconstitutional about this so far. Okay, probably Daniel might agree. But now, if a state takes up this proposed rule change and it needs to amend the state statute to do so, then again, the state is given the required due process if it schedules hearings or adopts or rejects the bill, has the executive sign it, go along, or if it's permissible under the state's law, it goes before the insurance commission for a rulemaking process. Again, nothing here is unconstitutional. The state is actively doing what it's supposed to do. Okay, now, if the state does adopt the rule change through its normal rulemaking process, there is an opportunity for further public discussion and an opportunity for judicial review. Now, Dan might say that that gets short-circuited through the dynamically updating process. I'm going to hold off on that for just a second. I'll come back to that. Because these handbooks are really different than model laws. But by definition, they're accounting rules. What Dan is probably objecting to is a rule that is hardwired. So when a handbook is updated, the automatically updated one is the one that is used, and nobody actually has any scrutiny over that. But again, I go back to the idea that there's a lot of scrutiny on those rules, and I kind of reject the notion that it's done just to extract money from the industry or from the states or from insurance professors. Okay, but I agree this is problematic for the reasons that Dan explains. But I think it's still reviewable by a state court. I don't think it's unreviewable. So if somebody says that an insurance company would complain about the application of a particular change, its venue, its proper venue is a state court. Now the state court might throw up its hands and say, go talk to the NAIC, but that's a state court issue. It's not the NAIC's problem. That's really, I think this is a state issue where the states are allowed to review. Dan mentioned a Pennsylvania case involving workers' compensation, where the AMA was delegated the authority to look at what determines whether someone is disabled or not. And the court basically said, well, we can't delegate to that third party, and threw it out. But the state's remedy was to pass a new law fixing it and just putting those rules into law. That's a remedy. It's a lot simpler than throwing everything out or creating a hodgepodge of regulation this is constitutional in this state and this is unconstitutional in that state, and sort of tremendous regulatory uncertainty as a result. That would be a really bad problem. But I still think that all these things are potentially reviewable in state court, and people who litigate these things would know better than I. Okay. The second thing I want to do is talk about, do we want to declare that the NAIC's methods are unconstitutional in essence? Well, let's presume that occurs, and I guess I sort of led into this a minute ago. A state strikes down the rule, and then we have some time period where the state has to fix it. But each time this happens, the state is the one that's being charged with this. It's not the NAIC, it's the state's issue, and they can fix it. And now, what would be nice if a paper like this, like what Dan wrote, sort of gets people in the mind thinking, oh, you know what, we probably need to be a little bit more proactive on this. We need to have standards about when we adopt things from the NAIC, what that really means. And we have to have a more meaningful assessment when we adopt it. That's the state's problem again. So I think the states can do it. But I think Dan's pointing out is that he's pointing this out as a problem, and I don't think people really thought about this. And the topic of his paper is so dang provocative, everyone has to read it. So I think it's going to get spread around for that very reason. Now, should we use an interstate compact? Well, I want to talk about this slide in a second, but let me give you the interstate compact thing. So I don't know that we need an interstate compact. I think the states can do this. It'll be lumpy. People won't like it very much, but it can be done. But what would an interstate compact do for us in this case if the NAIC can't do for us? Well, Dan pointed out that he would expect that there be Freedom of Information Act requirements and things like that. That's because he's a law professor who wants data. And like I'm a business school professor that wants data too. So if we had FOIA, we could get data. Right now, the NAIC doesn't permit data to be shared. Now the states will do so if it's permissible under their state FOIA, but when the NAIC collects it, it's not necessarily available. But what would a interstate compact do? Well, if we had a multi-state compact and a company was injured by this rule, it would still have to go to the state, because the interstate compact basically makes what the rule is, but the state is the one that has to determine whether it's valid under its own state law. This is how it works for the Multi-State Tax Commission. I wanted to make sure that this is true. The only case with the Multi-State Tax Commission, there's two, and I'll talk about another one in a second. The only state where they are a defendant is a labor case where they allegedly discriminated against one of their employees. So the Multi-State Tax Commission is not a party to lawsuits, generally. Where if you wanted to appeal a decision of the Multi-State Tax Commission, if you were a taxpayer in Nevada and Nevada was a member of that, you'd be suing in Nevada courts over that. It's not some magical court in the middle, and it maybe as a matter of interstate compact law, you could give this binding authority on state courts, but I would think that states would still have trouble with that. So the Multi-State Tax Commission, the reason I wanted to bring it up is because when I was trying to figure out how many times it had been a party, I found the first time it had been a party, and it was a Supreme Court case when it was only a couple years old. U.S. Steel had sued it, claiming that it was an unconstitutional interstate compact because it had not been approved by Congress. And I thought this was really interesting. And the Supreme Court said, the Congress. What's interesting here is the court said, and they said it in another case, I think it's like Virginia versus Maryland, that if a state joins with another state in a multi-state agreement that does not interfere with the federal government's sovereignty, then it does not need to be approved by Congress. Because they looked back at the history of this and they were worried about treaties among the states that would set up armies or would allow the states to treaty with another country. That's what they were worried about. So they said this is a different kind of thing. As long as it's using powers that the state have and they're not enhancing their powers against the federal government, then we have no problem with that. So the Multi-State Tax Commission was not approved by Congress, but it is a multi-state tax commission. The NAIC is a multi-state agreement among state insurance commissioners. It is almost an interstate compact. I think all it would have to do is get the states to pass another bill, and it could turn magically into an interstate compact. Now, this is kind of a, I think, I don't know, it's not a silly argument, but there's a lot of other things that can go on here. Now, let's see, I wanted to talk, I think I have a few minutes left, I do. I want to talk about this slide, and I'm glad he put it up there because I was thinking about this exact issue. So one of the issues that comes up is that if you have a state that says we're not going to be accredited, what is the real effect of that? So Dan talked to you about what the law says, and what it could be if everyone was operating on full efficiency and really wanted to enforce the law the way it was perhaps drafted. But not every state has adopted this model redomestication law. I think 40 some of them have. Look, two major ones haven't, Illinois and I think New York. But what's really interesting is that the era of the internet has changing things dramatically. So Illinois, which is the headquarters to State Farm and Allstate, but State Farm. State Farm moved almost all of its employees to 3 different states. They still have their headquarters and their books in Illinois, but all their employees are someplace else. And they basically took all their employees out of the state because nobody wants to live in Bloomington. Evidently, that's part of the problem. So you can have an insurance business anywhere. Would accreditation matter? A colleague of mine at Georgia State, we've done a lot of work on, as I said, premium taxes. I'd say about half of the insurance companies are in the wrong state to minimize their premium tax bill. In addition, regulation, and we just looked at rate regulation, doesn't seem to push a company out of a state. So I think the state's regulatory environment, people are sticky to their states. Even if a state was unaccredited, I don't see a big change just because of the way companies and states are. Another thing is that while technically, let's suppose New York decided to be unaccredited, and it started this framework where 51 states were raining down on New York companies. Can you see Wyoming, the regulator in Wyoming, going after all the New York companies in its state? I just can't see it. They have one domestic insurance company. They don't have the staff for this kind of activity. Most solvency reviews are multi-state anyway. While there is some deference to the state of domestication, any state already has the authority right now, even if it's accredited, to go after that state. It has to ask the domestic regulator what's going on, but it can still, if it's writing business in its state, it still has the authority to issue all sorts of regulatory flaming arrows, if you will, at that company. So I look at this and I don't think this accreditation power is as strong as Dan might suggest. Maybe it is, but I just see how companies and states interact today, and they're sticky. Regulators do not have the budget to go after a big state company. I'm thinking small states like South Dakota, North Dakota, Wyoming, even Colorado. They cannot really afford this kind of extra regulation. So I think I think you called it a paper tiger. I think it's a threat without a lot of power behind it. So I'm just thinking that this, while it is technically true, it's not the hammer of accreditation. I want to say that the hammer of accreditation is that, especially for the case of New York, I don't know if you represent any New York companies here, but I always had the impression that the New York companies they decided, or the New York regulators said, we're New York, we don't need the NAIC to tell us what to do. We're New York, we're the best, we're regulators, we got Wall Street down. And I think the financial crisis hit them hard. And they may have been somewhat I'm making this up now, so it's not law, it's psychology, so I guess everybody can be a psychologist. If the financial crisis hit the insurance industry hard in New York, They might say, you know, maybe we need to become accredited. I don't know, I wasn't part of that discussion at all, but it's not the same thing as saying, you know, we're an independent regulator, we can go it alone. But they adopted principles-based regulation, in part because the world did. So my final section here is that section here is that the NAIC has been part of integral part of state solvency regulation. It's been pushed on by Congress to do so. It's been pushed on by Congress so hard that it was, at one time, it was an existential event for state regulators. So I think that the combination of sort of the practicalities of regulating in the world of this accreditation and the practicalities of having a hodgepodge of state insurance statutes being struck down. Think about it. If you're an Illinois judge and you had this case of non-delegation before you, think about the externality. I strike this down in Illinois. I'm not just doing it for Illinois. I'm making a dent across the country in states like ours. Would a judge, you know, understand that externality? Maybe some don't. Maybe state judges don't care. But I would think it's a very important decision. I think that would chill some of this behavior, as a matter of fact. So, in essence, I don't really disagree with Dan's problem. The problem he has with the state delegation. I think it's a real problem. But I also think that the NAIC's role in the regulation of insurance and Congress's backing makes up for a lot of it. Thank you.
Thank you, Professor Grace. So we're going to ask Dan to give 5 minutes in response, and then we'll ask Professor Grace for 5 minutes, and then we'll go to questions.
Should I stay here or should I go there? Or what?
Whatever you prefer.
I only went 2 minutes over.
No problem. All gold.
Yeah.
So first, I just want to thank Martin. I mean, his comments were excellent, and he raised really, I think, a huge set of points to think about. I obviously don't agree with everything he said, but I want to touch on a few of, I think, the most important points he made. So first, one of the key points he made, and it's one of the key points the NAIC will make, is this. Look, it's not like the NAIC has this power in a vacuum. States chose to delegate this power to the NAIC. States chose to do so, and they chose to do so because there are good reasons to delegate powers to the NAIC, but states don't have the practical capacity to do this. Now, all of this is, in some sense, true. Here's the problem, though. Even if a state legislator 10 or 15 years ago chooses to delegate power to the NAIC, it can't do so constitutionally unless there's some independent oversight. One way there might be independent oversight is if the legislator could choose to undo that. But the problem is that they don't practically have that capacity. The reason they don't practically have that capacity is the accreditation program. And I am sorry, this is not a paper tiger. Just for some evidence, you can go to my paper where I actually quote a presentation that state regulators made to the state legislator about why they had no choice but to adopt the NAIC Model Law at issue there. And the reasons were exactly this. And the state legislators acceded. You can see the same thing in New York, where eventually state legislators adopted principles-based reserving, notwithstanding their vociferous disagreement because of the threat of accreditation. And I would say you can see this by the very fact that every single state is accredited. Moreover, I would suggest to you that it is not, in fact, the case that states have a choice, and some of the statistics Professor Grace mentioned are not on point. It is certainly true that for most model laws, many states don't adopt them. I think he had numbers like, you know, the average number of adopting states is 15 or 16. True. Now compare that to the NAIC model laws that are deemed accreditation standards. Those are adopted by every single state. Why? Because they don't have a choice. If they had a choice, you would actually expect for there to be more divergence like what you suggest. The very fact that every state has adopted the NAIC model law on capital, the NAIC model law on reserving, which, for instance, creates the valuation manual and says we're going to defer to that, suggests a lack of choice. Okay? So the point isn't that this was just isn't that the NAIC forced states to do it. The point is states did it, and now they can't undo it, and that's what makes it unconstitutional. Even if Connecticut voluntarily decided, you know what, Dan Schwarcz is great, we love everything he said, he is now the Connecticut insurance czar, that still wouldn't be constitutional, because it would be Connecticut's legislator delegating the legislative power to a private entity. Okay. The next thing I want to talk about is the NAIC. So that's one sort of set of comments that I think Martin made. And I think it's really important to understand the fact that with a non-delegation argument, the point is the legislator can't delegate power to a private entity unless there is continuous oversight. The Constitution doesn't allow it. Okay. Point two, the NAIC process. Much of what Martin says is right. The NAIC has a process. I was involved in that process. I was an NAIC consumer rep. I see two former consumer reps in that process in the room. The industry can talk. Folks can talk. They have a process, except when they don't want to. And then they don't have much of a process. Or if they want to change the process, fine. If they want to have a shortened period, fine. If they don't have time for you, fine. If they want to pass something behind closed doors, fine. Because who's going to tell them it's not fine? No one. There's no independent entity that ensures it follows its process. And what that means is that we don't have the normal safeguards we would expect in administrative law. It's not sufficient. Connecticut couldn't delegate power to me and say, and, by the way, Dan Schwarcz, you should consult with 10 people before you pass a law, right? It would still not be acceptable. The Administrative Procedure Act and administrative law requires process and then requires courts to ensure that delegates of power follow that process. The NAIC doesn't have that. You mentioned that state regulators are involved in the process. True. But when they are involved in the process, they're not acting really as public officials. What they do in the capacity of the NAIC, it's not subject to FOIA. It's not subject to transparency laws. There are no conflict of interest rules. There are stories of someone chairing an NAIC committee on topic X, the next day going to the industry and testifying before that committee on topic X. Would never be allowed in state law, but they're not acting as a state public actor when they're at the NAIC. So it would also be impermissible if I worked at the Connecticut Insurance Department. If I were an employee of the Connecticut Insurance Department, the state legislator heard me and they said, you know what, you're great, we're going to delegate power to you and you can do what you want and you're a public official. No, right? Because even though I'm a public official, if you delegate power to me and I'm not subject to a public process in how I exercise that power, it's not a public delegation. You suggest there aren't large conflicts of interest. After all, the NAIC gets lots of money, most of its money not from its publications, but from its data. And I rudely interrupted you, I apologize for that, but I said, why do firms have to deposit their data with the NAIC, and then charge it? It's because that's required under the model laws that are required by accreditation. The NAIC Valuation Manual says you need to report all your data to the NAIC and, oh, by the way, pay a fee. You need to report your statutory annual statements under the NAIC Model Law and annual statements as they're adopted to the NAIC. So a huge part of the NAIC's funding model really is premised on the fact that states compel, via adopting the NAIC, insurers to abide by it. So I do think there are huge conflicts of interest, and I think it's really a problem. Okay. Finally, you raised a number of really important practical points, and I want to say I agree with most of your practical points. And it is true that the accreditation program was born out of the threat of federal preemption, and it wasn't just Dingle. It was actually a GAO report after that, not just the first, not the failed promises report, a second report that said there's no way states can solve this because no matter what, states in the NAIC are not going to be able to compel states to act. You want to know their solution? The accreditation program will compel states to act by designing a system that really doesn't give them much of a choice. And it worked, but it worked too well. Because at the end of the day, the reason you can't compel states to act is because they're independent sovereigns. That's based in their constitution. And by adopting this strategy to solve that problem, you created another problem. What I suggest is, yes, we would have huge practical problems if states did this. And yet, a state judge who is doing his or her job and applying constitutional principles, I submit in many states would be duty-bound to find this unconstitutional. That's not a problem with the states. That's a problem the states need to fix and address. And I'm not suggesting we get rid of the NAIC. I'm not suggesting we get rid of state solvency regulation. I'm not suggesting we federalize it, even though in my ideal world we might. What I'm suggesting is that we have a constitutional process where there's independent oversight by a public entity of the NAIC to ensure the NAIC is held accountable, to ensure that conflicts of interest are not driving its decisions, to ensure that there's process that's followed so that all stakeholders always have a say in what the NAIC does. That would not only create accountability, it would not only limit conflicts of interest, but it would prevent the very dire circumstances that you rightly point out we are currently living with. So I appreciate you engaging with me with this. I wish the NAIC would, and I look forward to a robust debate in the next few minutes.
Thank you, Professor Schwartz. 5 to 10 minutes from Professor Grace.
So I think I spoke my piece. I don't really have a response to your comments because my whole paper was, or my whole discussion was a response to your comments. And we've known each other a long time and we don't agree on many things, but we do have a big overlap here. One of the things that I was always worried about after reading Dan's paper was that how quickly could a problem like this be resolved? Because it's not every state, right? Some states are going to have relatively lax delegation doctrines, but other states, Pennsylvania, where I live now, has a relatively strict one. Other states with lax ones aren't going to do anything, and getting them all to agree on this is they talk about getting professors to a faculty meeting is like herding cats, but it's like a million times worse trying to get states to agree on something. So this is a major practical problem, and when we were talking, this is about a month ago, about how we would do this presentation today, I said the big problem is how do we get a solution that's workable? Because it's right now we have it's in a way it's science fiction, right? This has never happened really yet, and we're thinking about what could happen in the future, but it is so scary in many respects from a regulatory point of view that one should engage with the NAIC. One should engage with states that have very strict delegation doctrines to say, how should you deal with this? I mean, that might be a better, because the NAIC is going to say, you're just Dan Schwarcz, you're just some guy from Minnesota, whatever. But a state legislature who is a member of NCOIL, or 4 state legislators, members of different states, legislatures and members of NCOIL. I think that's the venue to get this message across.
I presented this.
Oh, good.
I presented this to NCOIL at their annual meeting at the plenary session, and many state insurance legislators were very interested and were very, very willing to think about this. I think you're right. The problem is that this is just a theoretical concern until someone brings a lawsuit. And I think I've spoken to many people who have thought about bringing these lawsuits and have told me that they think that they would be successful, but they're too damn scared of what the NAIC would do to them. And I think that says something. The solution the NAIC has come up with is ignore Dan Schwarcz and implicitly or explicitly, at least in the past, threaten anyone who threatens to bring this lawsuit. Well, it's not just, first of all, someone eventually is going to be able to bring this lawsuit. It's just a matter of time. And it's not just the lawsuit, it's what is underneath it, which is the lack of accountability and the conflicts of interest. And so I think the optimal solution is get ahead of the problem. Don't wait for this to be a problem. Get ahead of the problem. And, states did adopt a compact. Now, not every state is in the Interstate Insurance Compact, but many are, and it's growing. And again, if the nature, recognize, I'm suggesting something pretty limited. I'm suggesting like a small body rotating judges for whenever the NAIC acts with the force of law that reviews what the NAIC does. That's not like a huge lift, okay? That's a mechanism for ensuring accountability of the NAIC itself. It seems to me like most states should be willing to get on board with that. It seems to me like if the NAIC were thinking proactively about preserving their authority, they would already be on top of this instead of ignoring the problem. And I think it would have huge benefits, because whenever the NAIC acted then, it would have to be aware of the fact that what it did might be subject to review by the compact, okay? And so therefore it wouldn't act as inconsistently as it sometimes does. It wouldn't move things, it wouldn't sort of willy-nilly change deadlines or refuse to have public comment or shorten the process when they wanted to. They'd have to abide by certain procedures. And yeah, I think that would enhance the credibility of state insurance regulation.
So I want to give some of the people in the audience an opportunity to ask questions. For example, we have the former Insurance Commissioner of Connecticut here, Tom Sullivan.
Still the head of the Federal Reserve's insurance force?
So no one in the audience, of course, is obligated to ask questions, but I have many questions and very much enjoy hearing myself talk. So I want you all to get a chance to answer questions before I start. Ma'am? Dan, I apologize. We don't have microphones for the audience. Could you very briefly summarize? Yeah, before you answer.
No, and let me. It's an excellent question. So Sonia Larkin Thorne asked the question, and we're former colleagues, former NAIC consumer reps. We both left the program and have some issues with it. And Sonia asked a really excellent question, and one I agree with, actually, which is you're proposing this compact solution, but actually, if you look at the way the current interstate insurance product compact works, is actually more controlled by the industry than the NAIC is, and it has lots of problems, and I actually agree with that. Now, here's my response. My response is my compact would be different. But it's a real response in a following way. They would both be compacts, but they'd be really different. The way the NAIC Interstate Insurance Product Compact works is that it is delegated authority to come up with the rules that govern products and review those rules for compliance. And so it's delegated an authority, and then like any entity that's delegated an authority, it can be captured. Okay, and I think that frankly that can happen. It does happen. And I have lots of problems with the NAIC government. But the compact I'm proposing is fundamentally different. It's more of like a compact to create more of like a judicial type of entity as opposed to a sort of a regulatory entity, a reviewing type of entity. And so I'm imagining it really would essentially be analogous to a court that would review the actions of a state regulator, right? So if a state regulator passes a regulation, or even if they act in any way, it can be challenged under state administrative law in state court. And that holds, that ensures that state departments are accountable. I mean, state administrative law. I'm imagining a similar sort of process. So it wouldn't actually be making the rules. It would just be making sure the NAIC is following the rules. And I think that there's less potential for capture there because I think that it would be, again, my vision is it would be staffed by judges, a rotating panel of state appellate judges that would be applying sort of a pseudo Administrative Procedure Act similar to what we have at the state and federal level, but that was included within the compact. And so you see less capture in the judiciary, I think, right? Because and again, I'm not saying there wouldn't be any risk of capture, and I think you're right. I think it's a concern, but this is my practical way of improving the system rather than blowing it up. Because I think right now there's a possibility it could blow up. But I hear you. I think it's a really good point.
Tom?
I actually was going to touch on the solution. So, I like what you said there because of natural history. Somehow branded differently because, you know, ship history then, and the fact that it would not probably, you'd have to get 100% adopted. Troubles with getting 100% adopted. I would say, laying out the started it, I think. Federal government can't be wagging its finger. Policy regulation while respecting the caring.
Yeah. So, I mean, I think both points are really good. On the compact, again, I agree. I'm not so sure you would need the compact to have 100%. I mean, remember, as Professor Gray said, different states do have different non-delegation doctrines. And so this would be more or less of an issue in different states, depending upon the state and their non-delegation doctrine. And also, frankly, depending on the way that the statutes are written, there'd be a lot there. So I think you'd only need the states that basically had the real constitutional problems to adopt the compact. If there's one thing that motivates state legislators to act, it's the threat of losing their power. And that's why they did all this in the first place. So I think if they feared that this would be a fundamental threat to state insurance regulation, I think they would act. I totally agree. We need to brand it differently. We need to call it something different. And again, my vision is different. The compact is just the legal tool. Compacts can be done poorly or well. Again, I'm imagining it will be done well, but obviously you're totally right. There are difficulties here, and I can't get away from that. About having my cake and eating it too, you're also right about that. I support having national uniformity in solvency rules. It doesn't make sense not to have national uniformity. And yet, and I think the accreditation program is very good in many ways. State solvency regulation is way better now than it was before the 1990s. I mean, that's why this all happened. So I agree with those principles. The problem is the way that we ensure that we have it is unconstitutional and creates huge problems of its own, right? So you need to adopt, so it's great to have the outcome of uniformity and have the NAIC play that role, but if you've gotten there in a way that creates huge other problems of constitutional magnitude, that's not a good route. So what I'm trying to suggest is a better route to that outcome, to try to have my cake and eat it too, right? And what I'm suggesting is that states actually can use this idea I have of a judiciary-like compact to do what you're suggesting, to have the uniformity, to leverage the expertise of the NAIC and, frankly, their tradition, which, again, it does many things well. So I don't, and this isn't, I know it comes off as an attack on the NAIC, and in some places I get frustrated with the NAIC, and in some places I think the NAIC deserves the criticism, but it's also really a criticism, less of the NAIC, certainly less of its people, there's some very good people at the NAIC, than a criticism of the structure that was adopted in the 90s to basically stave off the threat represented by the GAO report and the Dingell letter and as I said, the multiple reports for the GAO. And you can't solve a problem by adopting an unconstitutional solution. So I'm saying let's fix that. And in the process, we'll get more accountability, we'll get fewer conflicts of interest, we'll get more transparency, and all those will be good. So that's I'm trying to have my cake and eat it too. But
One final point now on the accreditation. So if I brought back from the NAIC, modify it either as legislature, I can go through my authority. Through, I would submit to you that that has a lot of opportunity for it, adopted or not. Right? So, the idea of delegating away, not so much. On the point of way, similarly, by legislators has to be heard, there's opportunity. I think there's governance.
even the ones that are accreditation standards?
Substantially similar.
Right.
Okay? So, but it's not uncommon for, here, take this state for instance, bring a model law that's written verbatim by the NAIC. By the committees of customize the law in argument around, the NAIC doesn't,
Yeah.
so to speak.
That's a really excellent point. So in order to maintain your accreditation, what you have to do is you have to pass the NAIC model laws that are deemed accreditation standards or a substantially similar law. And you are right, some states tweak it. Here's the difficulty. If your law does not dynamically incorporate by reference NAIC materials, will it be deemed substantially equivalent? I bet the answer is no. Now, I think one way we could get around this is, so here would be another potential response to my paper, say, look, states, you can comply with the accreditation, and if the NAIC did this, I think that would be good. Well, look, states, you can remain accredited, okay, even if you pass a version of the NAIC model law that just incorporates by reference the most recent version of this document, but doesn't dynamically incorporate by reference, and we will call that substantially similar. The problem then is that we're not going to get uniformity, because then whenever the NAIC updates a law, and they update these manuals a lot. Some of these manuals they update 20, 30 times a year, okay? You're going to start getting all sorts of lack of uniformity in the states, and then you're going to end up not solving the problem you wanted to solve. The dynamic incorporation by reference isn't incidental. I mean, the dynamic nature of it is essential to maintain the uniformity. So you could potentially solve the constitutional problem by making it explicit that a state didn't have to dynamically incorporate by reference the NAIC model, but then you create the problem that you've undermined one of our core points here. Because then, now, you might fix it if every year the state legislator passes a new law incorporating by reference the last version. Now we have huge practical problems, and what if that doesn't happen? And now we have the state legislators being overly burdened, and we have uncertainty. So I don't think, I mean, that's another way of going. And, it could be. But what I would say is this, you do have absolute passage of NAIC model laws that are deemed accreditation standards or substantially similar laws, because every state is accredited. So, and those, what counts as substantially similar? The NAIC doesn't have good rules about that. Yeah.
So that lack of and perhaps your commission or compact or whatever you propose would cure some of that. So we don't know how or if substantially similar,
Right.
and whether or not the pass-fail associated with compulsion there has teeth. You determined a minute ago here, whether or not this whole accreditation process or whether it has substance.
So,
We can't see that.
Yeah, that's a really good point.
so Dan, I want to follow up on something that Tom said. I had a few questions for you because I think you'll have answers to them, but it's an important part of this contribution you've made. So I'm going to distinguish between something that's substantively undesirable and something that's unconstitutional, okay? Obviously, things can be unconstitutional and not be terribly bad substantively, but we don't do unconstitutional things. But I want to distinguish between the two. So first, I want to ask you about substance. Do you have fears that if you involve states more in the legislators, okay, that they're more subject to capture than the NAIC?
Yes.
Yeah. Okay. So
I mean, let's be.
Yeah.
In my, I'm probably going to get called out for this and yelled at by someone, but my experience, NCOIL is way more captured than the NAIC.
Well, they're all insurance.
Yeah, right. And so I do have that fear, and so that's why my solution isn't just give everything to the states and get rid of the NAIC. My
Right.
solution is hold the NAIC more accountable, as opposed to sort of give all the power to NCOIL or state legislators.
Well,
Yeah.
NCOIL is an interest group, so don't think they're not captured. They are an interest group.
Well, I mean, they're not they're an association of state insurance legislators
Care about insurance.
who care about insurance, but there's a tremendous amount of what I would say, actually, to reference your very excellent colleague James Quack, cultural capture.
Yeah.
Where it's basically they spend a lot of time with the industry. Many of them are in the industry when they're not a legislator, like they're insurance agents so. I mean, like I worry about that a lot. Yes.
So one more substantive question before I talk a little bit more about process. What's led you to conclude that the reason the states have largely adopted the financial standards you talked about, what's led you to conclude that that's because they feel compelled to do so rather than they've concluded as a substantive matter it's the right choice?
I don't take a stand on what they initially decided. Many of them initially may have decided substantively this is the right choice. What I say is, as a practical matter now, the current legislators can't take that back. And that's the relevant point for the non-delegation doctrine.
Okay. So if we shift to the non-delegation doctrine, what I broadly call process, I have a few questions. So the first is, assume no dynamic incorporation. Gone. NAIC doesn't require it. Okay. Still unconstitutional, the regime?
No.
Okay. So, and you've said that one of the problems with removing dynamic incorporation is that it'll undermine uniformity. And one of the reasons we do this is because of uniformity. But isn't that a bit of an overstatement, right? It's not just uniformity, because something that was uniformly bad would be undesirable. Like, imagine if, for example, President Trump wrote the insurance regulations himself, right? Like, they would be uniform, but they would be a disaster. And so the thing I don't think I'm saying anything controversial regardless of your politics.
Martin's a Republican. No?
Is it-
Libertarian.
Is it your, and so let me ask impact the question a little bit of a different way. And this ties into something that Tom said. There is a substantially similar requirement, right? Do you view the substantially similar requirement? And I know there's not a lot of transparency about what it means, which is an issue. But do you view it as a floor or a ceiling constraint? And let me tell you why I think that matters. If it's really just a floor, if really all the NAIC is doing is saying you have to enact these laws or something that's substantially similar, meaning substantially as good, and if it's much better, much stricter, we have reason to believe it'll be much more protective of the insurance function. Is that, I know you're going to say, well, it's unconstitutional, so it doesn't matter, but is that such a bad policy outcome that we have this quasi-private group enforcing a floor, but giving state commissioners the freedom to be more exacting? Because I don't know if you believe substantially similar serves that function. I think you might believe it serves as a ceiling. In other words, I think you might conclude that substantially similar means insurance commissioners who go beyond are going to lose their accreditation. But it's not clear to me what you believe. And I recognize you're saying, look, it's unconstitutional. That's a problem, period. But what is your actual view on whether substantially similar is a floor or a ceiling?
I think it's probably more of a floor, because the idea is you have to at least be able to do this. And so if you do more than this, you have more. I think it's even framed in the accreditation that you have to have sufficient authority, right? But here's the problem. It's a floor in some respects, but in a sense, floor and ceiling doesn't properly capture it. The real question is not, is it a floor or a ceiling? Because I do think it's more of a floor than a ceiling. But for my purposes, the real question is, does it require you to delegate power to the NAIC?
Right.
And I think, one, that's generally how it's understood. Two, that's generally what states do. And three, that's what state regulators tell legislators. That's what legislators believe. And I think that it's very, one of the reasons the NAIC doesn't want to be clear about this is because they don't want to say, oh, no, you don't have to delegate power to us, because this power is incredibly valuable to them. And look, independently, it's also good in some ways, because uniformity is an independent good, right? I mean, you wouldn't want to be uniformly bad, but if it's a question of like on a scale of 1 to 10, and like 10 is great and 1 is terrible, I might prefer uniform 5 to an ununiform 6, right? Uniform is an independent good. And so there are good reasons for it, but it's the problem with this solution of basically getting rid of the dynamic nature of the incorporation. It would be very clear. It wouldn't be unconstitutional. It wouldn't be a delegation of power at all. It would just be like, yeah, we like your rules. We're adopting your rules. They could do that. But then I think we get back to the problems we're trying to deal with.
But so the only part of that response that I don't doubt that you're correct, but I don't follow part of it, because even if there was no dynamic incorporation, wouldn't the state legislatures be functionally coerced into adopting the NAIC stuff every 2 or 3 years because of your argument that if they did otherwise, they would face tax and employment consequences that are significant?
Look, I don't think there's any problem with an entity basically going to a legislator and saying, hey, or a company going to look, pass, Amazon, pass favorable taxes, or we're not going to come to your state. That doesn't raise constitutional issues. I mean, legislators are coerced to do things all the time. It only becomes constitutionally significant when it's done in the context of delegate powers to me, and if you then take them away, and I'm going to coerce you in a way that prevents you from taking it away. Because then what it means is we have the delegation of power without the constraint by the legislator. So I think the coercion point becomes not significant from a constitutional perspective once we take away the dynamic nature of the incorporation by reference, i.e. the delegation of power.
And so, in some sense, you're unconcerned if, for example, your compact is set up and judges determine that, well, let me put it a different way. It very well could be the case that additional oversight by the states, whether or not it's in the compact form or some other form, results in exactly the same outcome, because the legislators could be like, we don't want to lose this business, right? Maybe they think it's a paper tiger, maybe they don't. But it could very well be that the outcome will be the same if you have more accountability. And so I realize you're saying, well, but if the outcome is the same and the method is constitutional, that's an improvement. And not just an improvement, it's required. But I'm asking you, do you believe that if we engage in a constitutional oversight In other words, if we don't delegate unconstitutionally, is it your feeling that the substance of the regulation is going to meaningfully change? Do you have a sense?
I don't know, but I think that there would be then an opportunity to go to the legislator, and the legislator has to, it's a public process. They have to follow a process to pass laws, and they're publicly accountable. And if they pass laws people don't like, they can be voted out. And so there's a process that's public that, you know, if an issue gains traction in theory, in practice, how much difference do I think it will make? I don't think it would make very much for most issues, because these are low salience issues. But I think the point is it would create accountability, and then that would actually affect the nature of the NAIC's
Right.
process. I mean, I think the biggest value...
The shadow.
Yeah, exactly. The biggest value of administrative law is not that, like, we ultimately get rid of the laws that don't work. It's that, like, it has an effect on how agencies operate that ensures, to some extent, that their processes are more rational and transparent. And that's what I want for the NAIC.
So, Professor Grace, you wanted to add?
He actually, he preemptively answered the question I was going to ask. But I think this really amounts to just if the insurance handbooks that we were talking about, or the accounting standards, if they were salient to anybody outside this room and rooms like this, then we would have lawsuits. The problem is they're not salient to anybody, or they're enough to cause frictions.
Yeah, let me say this. I actually think there are a lot of people who could bring these lawsuits. I actually think it's possible that an individual state legislator might be able to bring this lawsuit. That state legislator has been constitutionally deprived of his or her authority to legislate by past legislators who delegated power. So I think a legislator could bring this lawsuit. I think a company could bring this lawsuit. Now, I don't think a company would, because they don't want to piss off the regulator, and that's what I've been told. But it's possible a consumer group could, and I've been, there are some consumer groups who I think are interested in it. There are a lot of potential parties that might have standing to bring this, if you start thinking in robust terms. So you're right, it's low salience, and you're right, that's probably why there haven't been lawsuits. But, you know, I think that there very well could be.
So, more questions from the audience. Professor Kogan?
So, the NAIC has not wrote you a letter. I'd be interested to hear, did they have any sort of,
They were,
substantive
yeah.
response to this?
No, I would
If
say
you're free to disclose.
Yeah, I would say yes, I'm free to disclose, because I wrote her an email and she wrote me back. And, you know, I wrote an email, basically, I sent it to my contact. I know people at the NAIC, and, you know, I think they mostly know me. And I sent it to them. It got to their general counsel. The general counsel wrote me back an email saying, you know, thanks for sending it. You're wrong on, it reads like an NAIC hit piece. You're wrong on the law, you're wrong on the facts, and you're wrong on the application of the law to the facts. And that was it. I then sent back a substantive email back saying, look, thank you for engaging. Here's sort of why I disagree with you, breaking it down here. Please explain. They didn't respond. And then they refused to respond anymore. There was one other setting. It was at a conference where I happened by chance to be on a panel with someone high up at the NAIC. I'm forgetting his name, but I think someone who's quite high up at the NAIC. He's the head. No, I'm forgetting. I could come up with, but he substantively engaged a bit more, but it was sort of ad hoc and it wasn't planned out, I think. And you know, he made some of the points that Martin made. You know, but we need to be able to have this debate out in the open, and they need, and they're not doing that. Their strategy is to ignore it, and hopefully it goes away. And I also want to be clear about this, even though, you know, I like to think that I have done a lot to really explain and detail this argument. I'm not the one who came up with this argument, right? I mean, this has been around. It was actually Congressman Ed Royce, I believe, who has voiced this in and actually I got interested in this when I was testifying to Congress, and I think it was Congressman Royce. It might have been someone else who brought this up. I was like, well, that's really super interesting. And then I looked and no one had really written about it except for, you know, like, and so that's why. So it's not like I'm like some crazy crackpot. Congress people have brought this up. Roy Woodall actually has an op-ed from like, I think the early 1990s bringing up this issue. I mean, there are other people who have brought this up. It was brought up to the legislator of, I think I want to say, I forget a state, but a state had this on one of its agenda and actually passed a, very limited intervention. So this is a real issue. It's not, and there are people who, this has been around, but I think, now it's really been thought out a lot more.
Yeah, I mean,
I believe they've never formally responded in writing. I believe that at some hearings, right, they might have been asked about this by maybe Congressman Royce or someone else, and they sort of said, a few general things. They said something in the panel, but they're not engaging with this substantively in a detailed way in public.
so, I mean, I think I want to say for the members of the audience who are on the live stream, this is a very serious issue. This is a very serious paper. The idea that it was a crackpot or out of left field is ludicrous. It's weighty, it's well researched, and it's an exceptional piece of scholarship. Now, I can say, as someone who shares considerable skepticism about the federal government directly regulating insurance, one of my expertise areas is ERISA. Federal government's regulation of benefit plans is complete, and in some ways, it's been a complete disaster. So, federal regulation is not, in my view, always the answer. But it's papers like this. You read Dan's paper, and you think, wow, there are some serious challenges in our current system, which I'll put my cards on the table. I think the NAIC has done tremendous work in a lot of respects, as everyone at this table agrees. And I have real concern that arguments that Dan makes that he's right about will lead to a regime that is substantively worse. That is not a response to his constitutional arguments. That's just an honest confession about my reaction, which is, well, Dan may very well be right, but I hope the world he creates is one that's better than the one we're currently in. And I've seen lots of times where the alternative is not quite so good as we might hope. So I want everyone to know, from a law professor's perspective, incredibly serious, incredibly provocative, incredibly well thought out article. And we have a minute or two. If there's any questions in the audience, sir, I think you said you had a question. Okay. So anyone, one final question.
I'm the non-lawyer in the room. Talk to me about statement laws versus.
Those aren't, the ALI doesn't have any power. This is a model law. So, for instance, I'm not saying that NAIC's model laws that are not part of the accreditation program that some states adopt and some don't are unconstitutional. They're totally fine. Model laws are fine. What the problem is when a model law delegates authority back to an, so it'd be the analog would be that the ALI's restatement says, and whenever there's a difficult case, you have to consult a counsel of the ALI. And now we're going to go to every state and say that if you don't adopt the ALI, none of our members will practice in your courts. Now that would be a problem. And that's, I think, what we have here.
Well, we've reached the end of our allotted. Oh, Tom has one final question.
Be careful what you wish for. Because everything you just said, Ernest, when we live in a world, and this is the predicament the NAIC is in, where product innovation I would turn back to you and say, and I don't think the answer, by the way, but what is effectively happening by growth of the NAIC is by virtue of that. If you don't have what we currently have, having the guardrails that exist, that are what you wish for.
And it'll all be Dan's fault, I think is the. Well, thank you so much, everyone, for attending. We really appreciate it. Professor Grace, Professor Schwartz, thank you so much. This has been delightful.
Good job.